here. I think, as most of you know, I'm Bob Jerry, and I'm Dean of the Levin College of Law here at the University of Florida. Those of you who have heard me say a few words at what we might call a law and technology event know that I really believe the world is changing on all of us in the practice very, very quickly. I don't endorse it, but to illustrate my point, I keep on my hip an app on my iPhone called Shake. And some of you know what it is, but some of you don't. I mean, we could make it very quickly a contract right here on my iPhone by just hitting a few buttons. It'd be very serviceable, and it would work. It'd be state specific by the time we punched a couple of other buttons on here. And then not the least is I've got my golden retriever thinks there's a little person who lives in this phone. Her name is Siri, and that I talk to her once in a while, and she talks back to me. It's fairly primitive technology as it goes, but if you just pause on that for a moment and realize that in the foreseeable future, there will be computers to which a client can speak or a business can speak, and there'll be enough processing power and information in that device that it will be able to provide serviceable legal advice back at a fraction of the cost of what lawyers can do in a face-to-face meeting. So that's just a small glimpse into this new world that is right around the corner on us. And I'm really proud that at your law school, we have the International Center for Automated Information Research that thinks about things like these and is looking at ways we can bring this to you to do a better job of preparing you for that profession. Right now, we're doing a lot through what we call the e-discovery project. The director of iCare, Adjunct Professor Bill Hamilton, seated right over there, is leading our e-discovery project, and we have a lot of things going on in it. So if you aren't familiar with it or getting to know Bill and some of the things we're doing there, and you're interested in this field, this is the right place to be coming. Through iCare, Professor Hamilton has created a lecture series, and I want to introduce our lecturer that we have with us today. I'm delighted that Jason Barron can be with us. He joined Drinker, Biddle, and Reith, a law firm in Washington, D.C., in October of 2013, and is of counsel in the firm's Information Governance and E-Discovery Group. Previously, he was served for 13 years as the first director of litigation for the National Archives and Records Administration. He also held positions as trial attorney and senior counsel in the United States Department of Justice, where during the 1990s, he acted as lead counsel in landmark litigation involving the preservation of White House email. He has served as co-chair on the steering committee of the Sedona Conference Working Group on Electronic Document Retention and Production, and he has served as an editor-in-chief on 3 significant Sedona commentaries. He was a founding co-coordinator of the U.S. National Institute of Standards and Technology Trek Legal Track, a founding co-organizer of the DESI Discovery of ESI Workshop Series, and a visiting scholar at the University of British Columbia. He currently teaches e-discovery as an adjunct faculty member at the University of Maryland, and he's served on a number of advisory boards, really too many to mention here. But he was recently recognized as an e-discovery trailblazer in the American Lawyer's August 2013 issue on the top 50 big law innovators of the last 50 years. Great to see him on that list, and he is with us here today. He received his law degree from Boston University School of Law. Don't know how we let him get away from the University of Florida, but somehow that happened. But it's great to have him here today. Mr. Jason.
Thanks, Dean, and thank you, Bill Hamilton, for inviting me. It's an honor, a privilege, and I must say that I had a long career in government. I'm a big cheerleader for public service. If anyone here thinks about working at the federal level, you should definitely see me. That's separate from e-discovery. I spent 33 years in practice in the government, 12 of which at the Justice Department as a trial lawyer, and then 13 years as Director of Litigation at the National Archives. On October 1st, 2013, during the government shutdown, I was declared a non-essential employee, which was a blow to my ego. And within a week, I had quit. I had retired and then gone to the private sector. I had planned to do that anyway, but here it is. And so I'm experiencing kind of a second career now in the private sector with really interesting expectations that we can talk about in terms of the world of information governance and discovery. Those of you who were at lunch just a little bit ago, well, if you weren't there, then you missed out on a conversation about drones and robo-insects and data streams of the future and Rule 34 request to produce. And so I'm not sure that I have anything as out there and fancy to talk about as our lunch conversation, but a little bit of that is going to enter into my sort of enthusiastic talk as to why e-discovery is important and why thinking about the world of electronic records is important for the practice of law. Let me see if this works. So what I want to do in the time period we have, and I'm going to end at 1:50. Those of you who have other classes can go, and then we'll stick around with other questions or whatever. And hopefully we'll try to make this as interactive. If anybody does want to pipe up during this talk, please do, and I'll repeat the question for the video otherwise. I want to talk about a world of big data that we are all in, a world of information overload that we are experiencing in our personal and professional lives, regardless of whether you go into e-discovery practice or anything. It is a fact of life in 2014 going forward. On a day-forward basis, the rest of our lives are going to be filled with data issues, and so we should deal with it as lawyers. I want to go back in time to talk a little bit about the dark ages, which I mean by pre-2006. I graduated law school in 1980, and how I practice law and what I've seen in the last decade, because I've really seen this acceleration in practice, and trying to fill in the details for you. I want to talk about what it means to be technologically competent in a very broad brush way. We could do a whole day's symposium on competence in technology, but just to sort of just brushing the surface and talking about it, I think we stimulate some thinking on it. And then I can give you some anecdotes and some thoughts I have about the great world out there. I am enamored. What I do is a lifetime program of reading. I go to Barnes & Noble, I go to Amazon, whatever, and pick up books that are related to subjects that I practice. And this, I guess I'm shilling this book. I don't get any money for it. But Second Machine Age by two MIT professors just came out, Work, Progress, and Prosperity in a Time of Brilliant Technologies. Let me just read a passage for a second here. I take it that no one here has been in the back seat of a Google car that is driverless. Anybody experienced this yet? Okay, so good. So in the summer of 2012, the authors went for a drive in a car that had no driver, and they were a little wary about this. We had visions of cruising in the back seat with no one in the front seat, but Google actually, understandably skittish about putting obviously autonomous autos on the road. Doing so might freak out pedestrians and other drivers. So the two of them sat in the back while two members of the chauffeur team in front. When one of the Googlers hit the button, the car switched on automatic. This is in California on Route 101. While we were headed down Highway 101, our curiosities and self-preservation instincts engaged. The 101 is not always a predictable or calm environment. It's crowded. It has traffic flows. The car performed flawlessly. In fact, it provided a boring ride. It didn't speed or slalom. It drove exactly the way a driver's is taught in driver's ed. And they had a good experience. Now, what they go on to say in here is that in 2004, this very prestigious book that came out, The New Division of Labor by Frank Levy and Richard Murnane, basically said that driverless cars would never happen. This is 2004. Because it's just too difficult, and that driving is in the domain of human workers. Computers would not replace drivers, and so computers cannot easily substitute for humans in jobs like driving. And this is 2004. Fast forward to 2013 or 2012, and the authors are experiencing something completely different. In fact, the authors go on to say that the ride they took, there have been 150,000 or so hours in autonomous cars so far. There's never been an accident by Google, by the car itself. There's only been two accidents. One occurred in the history of the program. One occurred when a person was driving the chauffeur car, so a human had the accident. and the other happened when a Google car was rear-ended by a human driver. Okay, so the robots are doing something that, that humans have been thought, even in 2004, that it would never approach something that is a human skill. Now, a lot of the same kind of whoa reaction to the future is happening in the legal profession, that for a long time we have been reliant on our own skills as, the minds of lawyers, of being able to practice the art of lawyering without a whole lot of help by machines or software. But the world has changed, and it's accelerating in a way that we need to have a conversation about being smarter in the space with technologies. And the reason I say that is here. Where I practiced, when getting out of law school in 1980, the traditional document review method was looking at boxes, looking at paper, and a labor-intensive exercise, linear review, basically going through paper, going through boxes. It could be hundreds of boxes. It could be in a warehouse of thousands of boxes. But that was the experience of lawyering. There is a RAND study that actually is really good to read in this area about how questioning the ability of all of us who get tired each day to actually do document review. And this is my life in the 1980s, which was that essentially a lot of boredom in going through huge amounts of paper. And I think the good news is that there's still paper to go through. But the good news is that the profession is changing, and we need to do something other than what I experienced in terms of discovery practice in the years after law school, which is that we need to have a skill set that deals with the world of electronic stuff and big data. And I think it's a lot more interesting than going to warehouses. So the world has changed, and the world that we live in is, as you know, one where there is really an accelerating pace of data being stored in the world. There's a figure here, 1,800 new exabytes a year. I have a movie on YouTube that I encourage everybody to see, eDiscovery Did You Know? It's a 7-minute time waster if you want to get away from your studies or your exams. But it is a world of burgeoning data with no end in sight in terms of the amount of stuff. There's more data in the world that's been created in the last 2 years than in all of history before that. There's, you talk about Library of Congresses, there are hundreds or thousands of Library of Congresses equivalent of stuff that is created in the world each year. And we're now looking at beyond what we used to think about as gigabytes and terabytes and petabytes. There are petabytes of White House stuff coming into the archives where I used to work, and exabytes and beyond, and the world of zettabytes. So it is a world that is that we're just confronting, and all of us in every discipline. So the question is, in the legal space, how to deal with it. Now, the old way, the old style way of dealing with large databases, which some of you might confront in a case where you have millions or billions of pages, is to take, like in the Lehman Brothers investigation, take a huge universe of pages and do keyword searches against it. And I'm going to talk a little bit about why keyword searching, we've moved beyond that, and so what it means to be competent. But this I consider to be a little bit like a Jurassic Park dinosaur of a case, of an investigation, because essentially no software, no fancy analytics were used. Basically, keywords were used against a huge data set, and then hundreds of attorneys were essentially used as contract attorneys to cull down and look at what were hits by way of keywords. This doesn't work anymore. It doesn't work because of scaling issues that we'll get into. So that you can look at that and say there's got to be a better way than approaching large data sets by either manual review or keyword searching. The world is a world of, let me make sure I get this, that the world is of unstructured data, which means that email is sort of semi-structured, but you have databases that are structured, and you have unstructured content of communications of all forms, whether it's email or texting or otherwise, that are streaming in, that everyone is creating, everyone is receiving at the desktop, and it's all potential evidence that needs to be at least thought about in litigation. And you have obsolete documents that you need to get rid of under record retention policies. You have duplicate documents that you need to dedupe, so you need to know something about deduping. And then there's this statistic here about not being available for traditional search means in terms of keyword searching. And I'm going to talk about predictive coding and machine learning in a moment. So we live in a world of big data. And that's the reality. Now, searching the haystack, you may think that Google has somehow solved this problem. And the experiment or the lab kind of exercise that I do in my classes teaching e-discovery is to try to point out what the differences are between a Google search and an e-discovery search. There are at least three things. One is that the task is different. If we, I am a guest here of Bill's today in Gainesville, and we went to a restaurant last night. If Bill wasn't around, the dean wasn't around for dinner, I would have gone to my device and my iPhone and typed in on Google restaurant Gainesville. And that would have produced, as you all know, hundreds of thousands of hits. But I wouldn't be going through the entire data set to look for a restaurant. I'd be looking at just the first page or the second page. But as lawyers, we have a duty, a competence really, a duty of diligence in terms of meeting our competence obligations under Rule 26 to essentially certify in any kind of discovery production that we have made a comprehensive search. It doesn't have to be a perfect search. Case law and e-discovery says not perfect, but a reasonable search and a comprehensive one. And when you have a Rule 34 request to produce that says, give me any and all documents on a subject, well, what does any and all mean? It doesn't mean just those first 2 pages for a restaurant on Google. It means a reasoned approach, a defensible approach to looking at all of the evidence that might be available for the lawsuit. And so it's a special obligation that's different than the Google experience. The second thing that is clearly different, when I had to search White House email as a lawyer at the National Archives, the email is not ranked by popularity. So on a Google search, the most popular restaurant in Gainesville will inevitably be ranked for search optimization reasons and for other reasons at the top of the list. But email is email, and so it's not a priori ranked. That's a second difference. And the third one, which is very interesting, we touched on it at lunch today, is that no two people in this room will do the same search on Google, even using the same words. And this I didn't actually realize until about 5 years ago, but it is a well-known phenomenon that Google itself is basically interpreting your prior requests and your prior searches in a way that changes the rank ordering of what you actually get in response to a search. And so this is not good as a lawyer in terms of having two different people doing the same terms into a database and getting different results. Is that defensible? And so you can't just say that the Google algorithm solves all of our problems as lawyers. You have to have a more intelligent approach, smarter approach in e-discovery than that. So that's part of the competence equation. Now let me take you back for just a couple of minutes on this big lawsuit that I was part of, and then I'll fast forward to the present. Part of my career was doing White House email. I worked on a case called Armstrong versus EOP for 7 years. I spent 10,000 hours at the Justice Department working on this one case. Malcolm Gladwell says that in his book Outliers that if you work 10,000 hours on anything, you become an expert. And so I got captured in the world of email and electronic records. And so I worked on that and became an expert, and then came to the National Archives on email policy. And then the tobacco lawsuit, U.S. versus Philip Morris, which is still going on, was filed in 1999 against 7 tobacco companies, but they in turn filed document requests against 30 federal agencies. And the task for me as Director of Litigation at NARA was to search against all records that the National Archives hold on tobacco. I got a 1,726 paragraph document request and had to deal with it, the last paragraph of which said all the other paragraphs apply to the National Archives. So it was something I had to go back and search against 1950 records on, all the presidential libraries that the National Archives have, but particularly what the defendants were interested in, the Philip Morris defendants were, they were looking for Al Gore's email because Al Gore dreamed up the lawsuit. Or at least that's the story that they chose to go with. What I got focused in is on searching through millions of White House emails. And the question is how to do this. Now, if you were all tasked to search through, let's say, a senior partner at a law firm, tells you today, go search through a database for tobacco-related stuff, what would you do? The first move one would think about doing, at least back in 2002, 2003, and maybe even today, is to dream up keywords to type into a database. You have to work with an IT person to actually go into the database. And that's what I did. And I will tell you how Julie Andrews comes into this equation in a moment. So that's what I did. And I dreamed up a bag of words, which is the way lawyers practice law through the early 2000s as best practices here. That's what considered competence, to dream up enough words to get enough documents that were relevant in the database. But the problem immediately became apparent that if you dream up words, almost any term that you dream up has multiple meanings to it. And so there's a phenomenon that comes out, which is that there's a lack of precision. There's noisy terms. You get a lot of stuff. If you put in the word Marlboro, you get a lot of email in the White House database that's about Upper Marlboro, Maryland. And similarly, you get instead of Philip Morris Institute for PMI, you get in the Clinton era, you get a lot of emails about presidential management interns. I will let you figure that one out. And my favorite is that typing in TI, or Tobacco Institute, well, if you put TI into a 30 million email database, what you get is a lot of Spanish preposition stuff for whatever reason, and you got Julie Andrews emails, or at least related to The Sound of Music, that talking about the song Do, Re, Mi, Fa, Sol, La, Ti. This immediately struck me as kind of a fool's proposition to be spending a lot of time trying to separate out noisy terms and doing Boolean searches. And if you look at the case law, and I'm sure Bill covers the Victor Stanley case in his e-discovery class, you have pages and pages of Boolean terms. That's what the Lehman Brothers is, pages and pages of Boolean terms. Now, in terms of ands, ors, I'm saying Boolean is just and, or and not. And that's the way that practice law. But the problem is that you have, if you start with 20 million emails and you are using keywords and you get down to 200,000 hits, and then you spend 6 months going down to 100,000 documents, it takes time, it takes a lot of effort, and you're finding a lot of noisy stuff. Your precision is, in this case, it was only 50%. 50% were relevant, 50% not relevant, and there's a bunch that are privileged. This doesn't scale. All of you are approaching a moment in the profession where it's very difficult. There's small and medium cases that you can do keyword searching in, but the competence that you need is to understand the kind of cases that you need to do something beyond that, because it's just too difficult to search through billions of electronic objects. And in fact, if you actually did a search through 1 billion objects and doing it at 50 documents an hour with a certain number of people, on task or whatever, it would take forever. It'd take 50 years to complete. So we have to be smarter in this space. So my journey in this area has been one where I recognize this problem. From a logical perspective, I wanted to find, my journey for the last 10 years has been one where I wanted to find better methods to search through electronic evidence and to find the stuff that's in the left top there, retrieved and relevant to litigation, to not find the stuff that's not relevant, to not spend much time on the upper right, which is not relevant and retrieved. You have to spend some amount of time through noisy stuff, but try to minimize that as much as possible. And worry about false negatives. Worry about the documents that are the smoking gun documents that you don't retrieve by keywords or by any other method. And so I won't go into, because a limited time here, what I did is, this is sort of a pun here, my own trek. I started talking to people. I went to smart people. And this is a key for you in your future. If you don't know something, go find smart people in the space, either other lawyers or IT people or otherwise experts to consult with. I went to, on my own track here, and went to, from the tobacco litigation to the Sedona Conference, which is a nonprofit think tank that I've been associated with for a decade. I went to NIST, the National Institute of Standards and Technology, and founded something called the Trek Legal Track, which was a research exercise to evaluate different ways to search through information. And now I'm off on talking with Bill and with others this week at an ABA meeting in Tampa about international standards in this area. All of this has been a movement in the law forward, where you do need to confront the fact that there's a new thing in the world, which is that has emerged, which is an understanding of predictive analytics, predictive coding, technology-assisted review, machine learning. All of these terms are the same thing. So part of the movement in e-discovery is that the case law has now embraced a certain amount of technology that we all need to at least be aware of. And the fact that you've been at this lecture, or anybody listening to this, you've got a leg up on every other person who didn't choose to come here today, and in terms of your practice. Because if you do a little bit of reading about predictive coding, predictive analytics, and e-discovery, you would be golden in wherever place you are. I say this because you don't have to know what's under the hood. There is, we talked about this. I asked the question at lunch whether people are scared by e-discovery, and there seemed to be universal consensus, yes. But the fact is that the good news is we fly planes all the time. We don't really know what's in the engine and how it works. We trust that the pilot is flying. In a similar way, for judges and lawyers, there's lots of mathematics that are going on under the hood in e-discovery in terms of doing better searches, better search methods through the space, and automating parts of the process. But you don't have to know the mathematics down to the last detail. You rely on people who are your consultants and experts to do that. What you have to know is to ask the question of whether this is a case that you would apply these advanced methods to. And that's true of any question that you'd ask in the space about competence. And so in just a minute here, I'll just say that there is a real sea change in the law. And what e-discovery courses now going forward have to confront is that there are judges like Judge Peck in the De Silva Moore case in 2012 that are basically telling the profession that you need to know something about these new methods, because they are, you don't have to be a guinea pig anymore. You can say to your client, hey, a judge has endorsed predictive coding and using algorithms to find documents in fancier ways. And I don't have time to go into the details. I'm certainly happy to have a conversation about what technology-assisted review and predictive coding is all about, but it essentially is back to this clustering algorithm. It is basically a way to cluster documents together. So all the fantasy football documents are over here, and you can eliminate them fast, and all the documents you really want on whatever subject you are after are over here. The machine does that based on a seed set that you populate yourself. And so the machine does all the work. And what I'm here to say is that you have to know something about this space, but not a tremendous amount to be a real leader in whatever place you end up. And it's I encourage people to read about these cases and encourage people to have a conversation about them. But it is, I admit that it can be a little bit scary doing things that are non-traditional in the law. Law schools don't really talk about what I'll go past this, but my next slide is these alien features. By the way, I have fun. I work at the National Archives, so I'm always asked about Roswell and the records about UFOs, and so I have my slides and I have fun. But the fact is that there is an aspect of e-discovery where we're confronting sort of industrial processes. There are millions of objects out there on backup tapes and electronically stored information of all forms, including in social media. And we need to figure out ways of dealing with that. And that means two things that are not traditionally taught in law school, but you have in terms of competence, you need to know something about. One is about sampling. One is about quality control. And you can read commentaries and you can look at cases about it, and I'm happy to have that conversation. But you need to know that there are these aspects of sort of professional practice that are good to understand on a very basic level, because you're going to have consultations with experts about it. The other part of sort of the new world that we're in is this, here, more Roswell, sorry, is a whole bunch of aspects of legal practice that, again, not readily taught in law schools, but you can look at the Sedona commentary and you can think about in terms of incorporating into practice, doing project management better, using experts in other disciplines to understand what data sets are all about, using the advanced search methods that I talked about, and cooperation. One of the big, whether it's a small case, a medium case, large case, whatever your practice is, the world is changing. Judges are expecting lawyers to be more cooperative with each other on technological issues. So even if you don't know everything, you can at least know what you don't know and have a conversation with others in the firm and others in wherever you work to be able to be up to speed, to have a conversation with the other side in litigation at a meet and confer. And it's very important to be cooperative in that space and not to be the kind of old-style zealous advocacy where you're not giving up anything. You have to have a conversation because, as we were talking about at lunch, the preservation duties are apparent on day one. When a lawsuit is filed in these days, in a digital age, we all need to preserve evidence. And that electronic evidence is going to be ephemeral or transitory unless you're quickly up to speed and figuring out how to get at it. I have been a big advocate in my career for using interdisciplinary approaches. So when I saw that there's a problem for the National Archives for the future in terms of handling big data sets, I went to people who were smart in the information retrieval community. And I would encourage you to think outside the box in legal practice, that not just dealing with what lawyers may know, but what others in other disciplines may bring to the table in terms of whatever practice you have. So it comes a moment here, and I talking to the dean and talking to Bill last night, where I guess it was urged to me that there is this feeling of what I looked up last night as Hellenologophobia, an irrational fear or hatred of Greek or Latin terms or of complex scientific terminology. And what I'm here to say is that that's not what e-discovery is about. Yes, you have to know a numerator and a denominator. And yes, a little bit about sampling and a little bit of mathematics, but it is not a geeky subject which is beyond the ken of anybody. I'm an English major, a political science major, and don't have a particularly scientific background, and yet I found my sort of niche in dealing with electronic records issues and with semi-technical subjects like restoring backup tapes in earlier years and otherwise. And so, anyway, I wanted to make that point, and I'm sure if anybody wants to debate me on it, we can chat later. The competence issue that I promised to talk about, there is a new comment in to Model Rule 1.1. We all, when you pass the bar, you have a duty to provide competent representation to a client. So that is a given, and that hasn't changed. What has changed in the wording of Comment 8 to the ABA rules is, and you can read it here, but to maintain the requisite knowledge, lawyers should keep abreast of changes, including the benefits and risks associated with relevant technology. Okay, so what does that mean? And as Bill and I were discussing, that hasn't been fully fleshed out yet. So the comment is there, and if you read the sort of the background of the comment, it's not really elucidating as to what the scope of subjects that they're talking about in terms of a lawyer and technology. And in theory, it goes well beyond e-discovery. For example, I have a list here: courtroom technology, advanced, how to set up a courtroom like this so that you can put on electronic evidence in a clean way, e-filing in courts with PDF formats and otherwise, metadata in documents, a lot of ethics rules about scrubbing metadata and not giving metadata to the other side that can be discovered, deleted stuff in documents in Word if you give it to the opposing counsel. You should know that that's not a good thing. Law firm data security certainly could be part of a conversation about technology competence. Legal research, knowing how to search stuff on both on the web and in traditional things like Westlaw or Lexis, and then e-discovery. So I'm talking about the e-discovery aspect of competence. There's clearly more in that comment that could be teased out in the future. And there's law reviews for you to write on the subject of all these subjects in terms of what a baseline set of competence for the profession is. For e-discovery, I really recommend as a takeaway, I have something by Ralph Losey. This isn't quite the EDRM chart that everybody sort of knows and is taught. It's Ralph's variation on the EDRM chart, but his blog, he's sort of a leading blogger in the United States, and if you go to www.e-discoveryteam.com, he does a wonderful job on a weekly basis of bringing people up to speed as to what predictive coding is and how to do sampling and how to do all the kind of things that that differentiate his practice from others, and really in a very lively fashion. And these slides will be made available. And there's a whole set of subjects that, yeah, as a sort of competency discovery, one has to have sort of some passing reference and knowledge of how to sort of work through on the workflow, the life cycle of records from being litigation readiness and information management across to actually producing evidence. But so it's there, and there's a lot to learn, but it is not something that is beyond the ken of anybody in this room. And if I can do it, you all can do it. Now, to even make it even more simpler than that, I really boiled it down to three pictures and one sort of summary slide. One is that we all have to know about email. Email is the killer document of the age. It has been for the last 20 years. It will continue to be, even though my daughter says that email is for old people, Daddy. She, if I send her an email, she's now in college in freshman year. If I send her an email, I don't get a response. If I send her a text, then, of course, I do get a response right away. So, but email in organizations is something that we all need to confront, and we need to figure out how to archive it, how to preserve it, how to search it, access it, and delete it in ways. And we could have a conversation about that. It's a hot topic, and if you know something about email, you got a leg up, because it seems passé in a world of social media and messaging, whatever, but it is still the bread and butter of what discovery is all about because of the candor of the medium. And all the cases basically default to email. And all the scandals that you read, whether it's, well, I won't name any because I'm on videotape, but all the scandals that you can think of, it's always emails of somebody that is getting them into trouble. So we need to have a conversation about that in this space. The next thing that one needs to know at a very basic level is the fact that beyond email, there's social media, and so Facebook and YouTube and all of the possible applications that are out there that we all use are potentially discoverable, and you need to know how to get at that stuff and what the boundaries are for getting at it. And so I think that is an important element of competence in the year 2014, and a growing amount of case law about how lawyers can reach into a Facebook page or not, whether you friend somebody that's not ethical, or whether it is, to find evidence, but certainly to demand it and to know how to get it in terms of either discovery demands or a subpoena are important. And then the third element, sort of boiled down, is the cloud. We are living in a world of data living in the cloud, and we all need to know about the risks involved in legal practice, in getting stuff putting stuff in the cloud for our law firms, having our clients putting stuff in the cloud. And there's a set of issues to work through, both in terms of pulling it back, whether you can ever extract stuff, what happens when a cloud provider goes bankrupt, in terms of getting records back, and basically just processing it. So, and in terms of privacy and security, there are a set of considerations. There are really good white papers from the Sedona Conference and other places on this topic. So one can get up to speed very quickly, but it's the world that we live in. And so if you don't know something about the cloud, then you're not going to be really competent in the field. But my lessons for this lecture are in some way, very obvious and simple ones. But it is what I read about when I see what others are saying about, to become an e-discovery expert. It's basically, you need to know what you don't know. And you need somebody to assist you, and I've made that point. You need to know at least as much as the local rules. So there are various local rules in the country, and judges have, in the federal level, they have their own rules of practice, and then there are local rules, both the federal and state, in jurisdictions that go through in a much more granularity than you would expect on e-discovery topics. And so one needs to be aware of the practice jurisdiction one's in and to be competent enough to at least understood that. You need to know about Rule 26 and Rule 16. Meet and confers are incredibly important because of the preservation duty in terms of legal evidence. And so one needs to be competent. You need to be anticipatory. You need to be sending demand letters out. You need to be anticipating that people are going to demand stuff of you to preserve evidence. And you need to have a basic understanding of the formatting of documents and how to approach dealing with the other side in a negotiation on a meet and confer. And as I've said before, you need to know something about cooperation. It is not enough to show up and just be confrontational when you're dealing with technology issues, because the judge will get mad at you. There will definitely be a moment where it is counterproductive to your client to be someone who acts as if you don't have to provide any information to the other side about the format or about how you're preserving stuff or how you're even searching for stuff. And there are issues at the margins about attorney-client considerations and privilege, and work product. But it's important to be receptive. So looking at the Sedona Cooperation Proclamation, seeing whether a judge year before has signed the proclamation, and understanding what the movement is in the profession towards considering this is part of what I consider to be technologically competent. I know I'm saying it broadly, but that's it. Now, the last part of the talk here, what I want to say is that my career paths for all of you. First of all, I've already said, if anybody wants to work in the federal government, I have a big Rolodex of people that I know. So there's certainly, we can have an opportunity for a conversation about that. Federal government may look a little further from Gainesville than it does from Bethesda, Maryland, where I live. But it is I am a cheerleader for public service at any level, state, federal, local, whatever, and we can have a conversation about practice going forward. What my practice is in the information governance group is one where we are trying to do some cutting-edge stuff. And I want to encourage you all to think about ways that are not traditional ways. So we've talked about e-discovery, and I've talked about best practices in terms of analytics and knowing something about predictive coding. And what I am attempting to do, and what others, colleagues of mine, are to have a conversation with corporations about how they can use these analytical methods to solve other types of legal problems. And so there's a range of issues that one can get into in this space. Information management, legal holes that are in effect. What if a corporation has 100 legal holes, but they have terabytes of data that they want to get rid of, and they don't want the storage costs? How do you advise a corporation on that? How do you advise a corporation if they have a whistleblower that's making allegations against the corporation that may or may not be true? Well, if you can download 100 million emails and look through them in a very fast process using methods that I've talked about, then you can give advice. You can say that your risk is very low or it's higher depending on what you find in the email. You can find bad apples in terms of people who might be harassing or might be doing things that are inconsistent with corporate policies. There's a lot of ways in which the kind of analytics that we have learned about in the e-discovery space can be applied to other kind of other disciplines. And I'd like to think that at our firm we're trying to be troubadours on this, and writing and speaking about ways to use these best methods in the space in sort of in untraditional ways. Now, whether you go in-house counsel or you become a consultant or you go to an accounting firm like the Big Four or in a law firm or government, increasingly every institution is going to be in a world of big data. So it is, as I said, it's something that we need to seriously confront. If you walk out of here and think that, well, that lecture might have been interesting or not because I'm not going to confront it, the fact is that every client is going to have email. Every client is going to have some electronic stuff that might be something that you want to look at. And so to know something on a technical level is, I think, really important. What is your niche? You can marry the discipline that you are interested in. If you're interested in health law or pharma law or working in telecommunications or any discipline, the e-discovery component, it's not just working as an e-discovery lawyer per se. It is knowledge of big data and information governance in the ways that I've talked about that you could marry with other disciplines. So it's not just a geeky, thing that for one practice group at a law firm. In our professional lives, knowing about how to preserve, how to access data, I think has tremendous application across any kind of vertical and any kind of corporate sector and any kind of practice group. And so for us at Drinker Middle, I mean, as 700 lawyers, we have been going around to different practice groups to make the business case as to why to use these kind of analytics for a variety of purposes that go beyond litigation. And so I don't want anyone to leave here to think that e-discovery is this very narrow foreign discipline. I believe that because of the world that we live in, I've tried to make the case here that we all should be interested in this kind of subject matter in whatever way that you practice.